um, Mr. Chang. It is just a few minutes past 1:30, so we will return from our recess for today's meeting of the New Mexico Oil Conservation Commission.
Okay, this is the court reporter. Are we on the record?
We are correct. We are now back on the record.
Sorry, I'm just used to hearing back on the record. Sorry, just making sure.
You're just a little ahead of me. But yes, we're going to get back on the record here. I don't think we need to call, well, let's call just for formality's sake, could Commission Clerk please call the roll again?
Yes, this is a roll call of our afternoon session. Commissioner Ampoma.
Present.
Commission Chair Chang.
Present.
Commissioner Balin Lamkin.
Present.
Okay, we have our quorum.
Thank you very much. Turning to the next item on our agenda, we have arguments for in the Goodnight Empire rehearing on the two issues that were that the commission granted limited rehearing on. Is there any matter that I'll turn to Commission Counsel. Is there any matter preliminarily that I need to handle before we invite the movement to start arguments? In that case, Mr. Rankin, are you ready to proceed?
Good morning, Mr. Chair. Thank you very much. I appreciate the opportunity with us today in the audience. We have some company representatives from the board and the company. From left to right, we have Mr. Charles Marsh, who's a board member, Mr. Robert Ruby, who's a co-founder of the company, Mr. Lane Skinner, who's VP of Operations, Mr. Matt Osborne, who's President and Chief Operating Officer. And then to his side here is Mr. Drew Winston, who's also a board member, and then Mr. Grant Adams as well. We appreciate the opportunity.
Thank you.
May I proceed?
Please.
Okay, Mr. Chair.
This is the court reporter. These are usually court reporters usually there. In 45 years, this is my, besides this morning, first time where I now have a picture of many people in the room. I don't know who's speaking. So every time somebody speaks, you're going to have to identify yourself.
Okay.
All I show is Pecos Hall. And sir, you're not Mr. Chang, so I don't know who you are.
So currently speaking is Mr. Chang. This is Chair Chang here on the dais.
Okay.
Hello.
It didn't sound like you. I saw somebody else, and that's what threw me off.
It's a new microphone now here, and I've got Commissioner Dr. Ampoma with me here on the dais. Commission Counsel is also with us here in the room. And we have a different commissioner from the State Land Office for the afternoon than we did for this morning, and that's Commissioner Balin Lamkin. Would you like Commissioner Lamkin to spell his name for the record for you?
No, I got that this morning.
Okay, great.
But I'm a little concerned about the other picture now that showed many people in there.
I understand. So let me do a round of introductions, and I will also then ask all the council to help me and the court reporter by identifying themselves when they speak and or interrupt with an objection or whatever else might happen. But I think, is there a way to turn the camera, or you know what, I'll just ask everybody to introduce themselves. That way the camera hopefully rotates and points the right person. So if you wouldn't mind waving for the cameras and each enter your appearances, that'd be, I'm sure, appreciated by all of us.
Thank you, Mr. Chair, Madam Court Reporter. My name is Adam Rankin, and I'm representing Goodnight Midstream in this case.
Thank you, Madam Court Reporter. Corey Waymeyer of Santoyo Waymeyer PC. I'm joined by Sharon Shaheen. We're here on behalf of Empire, and we're ready to proceed.
Chris Melander on behalf of the New Mexico Oil Conservation Division.
And Matt Beck on behalf of Rice Operating Company and Permian Line Service, LLC.
Is anybody present for pilot?
Yes, good afternoon. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Pilot Water.
Thank you. Is there anybody else we anticipate speaking up during this hearing? I don't believe so. If anybody else does pipe up, I will do my best to pause and provide identification for our court reporter. Does that help?
Yeah, it'd be even better if I was there. I did not know it was going to be this format. I am so sorry.
It's all right, and I'm just my apologies if there is any miscommunication on our part as well. We appreciate your efforts to help us muddle through as best we can, and please don't hesitate to pipe up if you need anybody to slow down or to re-identify themselves. The only other person that I can think of who might speak up is our commission clerk, who you probably will not be able to see on camera at all, but she is here with us in the room at the back of the room. Is there any other preliminary housekeeping items that the commission should take up before we proceed to oral arguments? Hearing none, I invite Mr. Rankin to open on behalf of Goodnight. I have 5 minutes. I have 20 minutes on direct and 5 minutes reserved for rebuttal.
That's my plan, Mr. Rehearing, Mr. Chair. And if I may approach, I have a hard copy of the presentation so I could share with parties. Thank you, Mr. Chair. I'm going to share my screen as I walk through my presentation. Mr. Chair, Commissioners, may it please the Commission. The Commission directed the parties to submit briefing on 2 narrow legal issues and instructed them not to relitigate any facts or factual findings found by the Commission. First, can the Commission suspend Goodnight's injection given that there's insufficient evidence that the alleged ROZ is recoverable? Second, does the division have discretion in implementing the Commission's order? In summary, as to both issues, the Commission's finding of insufficient evidence of recoverability precludes shutting in Goodnight's injection. That means the original order should be amended because there's no finding of current waste or impairment of correlative rights. There's no finding of production in paying quantities as to the ROZ, and there's no lack of confinement as to the injection within the injection zone conducted by Goodnight. Alternatively, the Commission did delegate and has authority to do so, to delegate its authority to the division to implement the original order. What does that mean as to the first legal issue presented? The answer is no. The Commission does not have authority to suspend Goodnight's injection without first finding, based on substantial evidence and reliable evidence, that the claimed ROZ is both economically and physically recoverable. Why not? The Commission's powers are not unlimited. It's a creature of statute, created by statute, and limited to the authorities and powers specifically delegated to it by the legislature. While it has broad authority and power to do what may be reasonably necessary to carry out the purposes of the Oil and Gas Act, even if not specified, the purposes of the Act are to prevent waste and protect correlative rights. The Commission's decisions and orders pursuant to that authority are necessarily constrained by the limits of its power. They must be based on substantial evidence, and they cannot be arbitrary or capricious. The Commission's powers and authorities are therefore anchored to the prevention of waste and protection of correlative rights, which is the basis of its power as recognized by the Supreme Court. From this delegation of power, the Commission has 3 legal bases to prevent waste and protect correlative rights. First, they have a general power, as I've discussed, to prevent waste or protect correlative rights as reasonably necessary under the Act. They have the specific power to prevent the drowning by water of any stratum or part capable of producing oil or gas in paying quantities. And then they have specific power by regulation, where injection fluids have exhibited a failure to be confined within the injection zone. These legal bases apply in every circumstance where there's a claim of waste or impairment or harm resulting from Goodnight's disposal. Whether you're talking about a potential ROZ in the Grayburg or the San Andres, or potential communication from the Goodnight's injection zone into the overlying producing Grayburg interval, these 3 legal bases are broadly applicable across all of Empire's claims. But every one of them requires a threshold finding that the alleged ROZ is both physically and economically recoverable, or the commission's duties to prevent waste and protect correlative rights are not implicated. With no hydrocarbons to recover, there's nothing to be wasted, and there's no correlative rights to be protected. With the commission's determination that it will not revisit the fact findings underlying the order, the facts supporting the order are now established and confirmed. There was insufficient evidence to prove that the ROZ, the alleged ROZ, is recoverable, let alone that it can be produced in paying quantities economically or commercially. Because the commission's powers are limited, it cannot suspend Goodnight's injection just because Empire says that it wants to develop a potential ROZ and refuses to proceed to do so while injection continues. Without proof of recoverability based on substantial and reliable evidence, suspensions of Goodnight's injection would be arbitrary, capricious, and not in accordance with the law. Now, up until very recently, Empire previously agreed that recoverability is a prerequisite to the commission to act. It alleged in each of its applications seeking to revoke Goodnight's authority that the alleged ROZ hydrocarbons are recoverable. And up until the hearing in this case, Empire even agreed that proof regarding economic recovery would be dispositive of not only the EMSU cases at issue here, but all the cases in which Empire was seeking to revoke Goodnight's injection outside the EMSU as well. This is not surprising because it is simply a restatement of what every seasoned practitioner of oil and gas before the commission and division will tell you the law is on waste. In fact, just this month in the rulemaking pending before the commission addressing financial assurance and plugging requirements, Calder Izell, the former 20-plus year law partner to Empire's current counsel, testified before this commission on behalf of the Independent Petroleum Association of New Mexico that waste requires commercially and economically recoverable oil or gas. That's also not surprising because physical and economic recoverability has been a requirement for proving waste throughout the commission's and division's orders. Recoverability is a part of the standard industry definition of waste in the Williams and Myers Oil and Gas Treatise, the Oil and Gas Bible. Recoverability is a required element of proof of waste in case law from oil and gas producing jurisdictions around the country. Just a few examples are shown here, but we have cited many more in our briefing. Now, having established that the recoverability is central to the commission's analysis and having determined that the commission has found that there has not been proven, let's look at how waste is analyzed in these three legal bases that govern and limit the commission's authority. First, the general power to do whatever is reasonably necessary to prevent waste and protect correlative rights. Looking at the definition, and the very definition of waste, the basis and the measure for waste is determined by what can be ultimately recovered. In other words, if no oil or gas is recoverable, then there can be no waste. Now, the commission found that Empire has failed to establish that the alleged ROZ is recoverable anywhere within the EMSU, including within Goodnight's disposal zone in the lower San Andres. The commission also found that by definition, the residual oil zone, as purported, contains only oil that cannot be mobilized by Goodnight's injection waters. Because the ROZ cannot be mobilized by water or injection of water, the continued disposal cannot tend to cause a reduction in ultimate recovery, even if at some later date the ROZ is proven to be economically, commercially recoverable. But more fundamentally, if none of the ROZ can be recovered or is proven to be recoverable today, technically or economically, then Goodnight's injection cannot cause waste because it does not reduce the total quantity that can be ultimately recovered.
Counsel,
Yep.
I want to clarify there and push a little harder because the commission's finding wasn't that there was sufficient evidence to prove that this ROZ is not recoverable. What the commission found is that there's no evidence one way or the other. We've read your briefing that covers a lot of these arguments, and the hard part for me to struggle with is the commission's finding here is that there's not enough evidence, whether or not each party agrees with that. The commission's finding was that there's not enough evidence one way or the other. And so what do we do when there is a possibility of waste because we don't know one way or the other?
Sure, understood. And as we our position has been, and because the commission, as the division does, has continuing jurisdiction, as and when Empire is able to come forward with actual evidence that the ROZ is recoverable, then they can come back to the commission and present that evidence. But until they do, they have not met their burden of proof necessary to shut in our injection. They have not met the standard of evidence required under the law to show that there is a basis for recoverability or that there's a basis to substantiate their claims of waste. And until that evidence comes forward, there's no legal basis under the law or the facts for the commission to shut in or suspend Goodnight's injection.
But is that technically possible for Empire to obtain the kind of evidence that you're looking for without the opportunity to do a pilot project?
We have heard from Empire's own witnesses that they can go in and drill cores and take additional evidence from the zone. They haven't done that. They acquired the property back in 2021 with the intent to pursue a potential ROZ development in the acreage, but have done nothing since the time they've acquired it. So in the record, which is before the commission, there was plenty of evidence from Empire's own witnesses that it is possible for them to go do that. They just haven't done it. They've elected to this date not to go collect that information. Fundamentally here, though, however, because none of the ROZ has been proven to this point to be recoverable, either technically or economically, Goodnight's injection cannot cause waste because it does not reduce the total quantity that can be ultimately recovered, which Empire has not proven to be anything greater than zero to this point. That's not waste, and it does not implicate the commission's powers to prevent waste. A similar result obtains under the correlative rights analysis. Again, as with waste, in the definition itself is the basis and the measure of what correlative rights are. And you determine it by looking at the ratio of the volumes of recoverable oil or gas. So you don't need to go any farther than this definition to know that without proof of recoverability, there can be no impairment of correlative rights. The ROZ here needs to be recoverable, needs to be proven to be recoverable for there to be an actual injury to correlative rights. Now, the definition provides further support for this conclusion. Correlative rights requires that oil or gas be capable of being practicably obtained. To be practicable, recovery must be economical. It's not practicable to attempt to recover non-economic, non-commercial quantities. And the quantities must be capable of being obtained. That is, they need to be recoverable. The bottom line is that the commission's findings that there is no current impairment in the Grayburg and no recoverable ROZ in the EMSU, either the Grayburg or the San Andres, are dispositive on the issue of impairment of correlative rights. Until there's an actual and present finding of impairment, the commission lacks authority to suspend Goodnight's injection. Now, looking at the second legal basis for the commission to suspend Goodnight's injection, the power to prevent drowning by water any stratum or part capable of producing and paying quantities.
If I'll briefly ask another question to help you see if you can maybe drill down a little bit more on the specific question that I think the commission is going to have to wrestle with. On this slide, for example, you've got the word prevent twice, right? Prevent usually means in anticipation. I mean, plain definition of the word prevent means to prevent something that has the possibility of happening, right? To prevent a fire by complying with the fire code. So I guess here's where we're struggling with. If it hasn't been proven that one way or the other, whether or not this ROZ either is or is not recoverable, it doesn't sound to me, at least from my reading of the commission's prior order, that we foreclosed recoverability. And therefore, if there is the possibility of recovery, but we just don't have enough evidence one way or the other, which is whether parties agree or not, the finding of the commission in its previous order, what do I do? I mean, doesn't the word prevent here, and even, and I think in a earlier slide, we looked at the word capable in the statute. Aren't those sort of probabilistic words that ask us to take protective measures to protect merely the possibility that this ROS could be productive?
Sure, understood, Commissioner Chang, and I understand the concern of the division where its ultimate obligation, the primary obligation and duty of the commission is to prevent waste. That's a serious and weighty obligation. And where there's a potential where you have a company who's telling you that this is a potential billion-dollar prospect, it's a serious allegation, which requires serious consideration and facts and reliable evidence. And here we have a situation where they're alleging a zone that has for decades been served as a disposal repository for produced water, as well as for production of water. Over 350 million barrels of water has been produced from that zone in that same exact location where they allege there's an ROZ without any production of gas or oil that's been recorded. So there is a strong demonstration just in the evidence alone that there is no hydrocarbons in that zone that are capable of being produced, number one. The concern here is that anybody can go along and say, hey, this formation has a potential for hydrocarbons. So, but I'm not going to go out and do anything about it. And I haven't done anything about it for the last 5 or 6 years, and I may not do it anytime soon. So I'm going to require everybody that has beneficially making use of this zone to stop doing so. Even though I presented no evidence after a 3-week hearing of any possibility of recoverability, and the commission has found that there's no recoverability. So the issue here again comes down to what is required during a hearing, which is proof and meeting the burden of proof. So of course, I believe that the commission retains continuing jurisdiction. They have an obligation, an ongoing obligation to ensure whenever there's an opportunity or possibility of a zone that may be productive, of always being able to step in and protect those interests. For example, whenever a saltwater disposal well is authorized for disposal of produced water, the division always requires that no matter what the evidence was at the hearing, no matter how firm it was that there was no hydrocarbons in that zone, they always require the operator, when they drill that well, to take swabs to check for potential oil production in that zone and to report any possibility of oil to the division, because the division retains ongoing continuing jurisdiction to ensure that no zone will be watered out by disposal of produced water. Nevertheless, the basis here and the reason that the commission should have comfort is because after a 3-week hearing, there's been no proof of recoverability, and the commission has determined that in this zone that has been targeted for disposal, there's no proof of recoverability. Based on this next legal basis, you'll see again that while it is anticipatory, nevertheless, it is required to show that such zones are capable of producing oil or gas in paying quantities. It is definitely a forward-looking analysis. And to date, Empire has not made that showing. As the division has found, okay, and as the definition under this provision requires, a strata must be capable of producing oil or gas in paying quantities, but Empire has failed to prove either with respect to the ROZ claims. And again, Empire must show that the formation is capable of recovery, that the oil and gas is capable of being recovered from that zone. And again, they have failed to make that showing. Under this standard, under this legal basis, recoverability is still a threshold fact issue that has not been established. And now the third basis, which regards the regulatory provision where injection fluids have exhibited a failure to be confined. Here again is the specific language. The commission or division are authorized to shut in or constrain or curtail injection from disposal wells only where the wells have exhibited a failure to confine the injection fluids within the authorized injection zone. Without these findings, and in this instance, as determined by the findings of the commission, Empire has not established that there are hydrocarbons in the alleged ROZ that are recoverable, that there's an exhibited failure to confine currently injection fluids within the disposal zone, or that there's any current impairment of correlative rights in either the Grayburg or in the San Andres, because there is no proven recoverable hydrocarbons in the San Andres. Without these findings, the commission has no legal authority or basis to shut in Goodnight's injection. Now, even if these findings are made and exist, The commission is not required to shut in injection. The regulations only give the commission discretion about whether to require a shut-in or not. The regulation uses the term may. But without these findings, the commission has no legal or factual basis to require injection to be shut in. In other words, the regulation, whether to shut in is discretionary, but the commission has no valid legal basis to shut in injection without making these critical findings, which the commission did not do.
Why is the finding of the existence of the ROS itself insufficient? Because the commission did find that there was a ROS down there.
Well, I agree that the commission did find that there is a ROS. I would push back and say that either under Empire's definition of a ROS or ours, there's been no determination that it actually meets that definition. We disagree. We disagree that there's a ROS in the disposal zone. We don't think it meets the criteria that Empire's own experts have identified, which is that it must be above 20% oil saturation.
Well, but the commission's findings of fact need to stand for this hearing. So how would you, so if you were to concede, or even if you want to reserve your objections on that point, given the commission's finding, why is a ROS, the mere existence of a ROS, insufficient?
There's oil in many places. The question is whether or not it can be recovered. If it's not recoverable, then it's not waste. By definition, waste has to be, waste requires proof that the oil can be recovered and it can be recovered in an economic way. And the commissions and divisions precedence on these matters is rife with circumstances where unless and until hydrocarbons can be shown to be recoverable and in economic quantities, then there's no waste. So here, again, because there's been no finding, and there's been actually an affirmative finding that the ROZ is not proven to be recoverable, there's no basis to shut in. Now, Empire, again, has the ability to go out and collect the data, and if they believe truly that it's available and they can do it, then they can come back to the commission at any time with sufficient data to show that the ROZ is actually recoverable in economic quantities. Until they do so, they have not met their burden, again, under the legal standards, and there's no basis to shut us in. So even if these findings, I'll move on to the next point here. Now, rather than analyze these legal issues as presented by the commission, as directed, Empire has instead undertaken the effort to substantially relitigate the factual findings contrary to the commission's order and direction. Empire argues repeatedly that the ROZ is recoverable, contrary to the findings in the commission's order and contrary to the evidentiary record. Commission's findings specifically, here are two examples. The commission found that Empire argued that it has proven at the hearing that hydrocarbons from the ROZ are economically recoverable, and they argued that the ROZ is sufficiently oil saturated to be recovered through CO2 flooding. But when you go through and you see the findings, these were all rejected by the commission. The commission ultimately.
Your time is about up, so I will invite you to just wrap up with your highlight reel.
Sure. So for all these reasons, the commission's final decision on whether or not suspension should be approved we believe, is incorrect. There's not sufficient evidence. Having found that there is not sufficient evidence for recoverability, the basis for suspension is not justified. As to the commission's authority to delegate to the division the ability to implement the order, we believe, of course, the division has authority. It has coterminous concurrent authority with the division under the Oil and Gas Act, and there are no limitations in the order that would restrict delegation or implementation by the division. So there's no basis to say that somehow the division's authority is restricted in its implementation. We think that the order is clear, that in our view, that the suspension is only required as and when injection occurs within the disposal zone. With that, I understand my time is up. I appreciate the opportunity.
Thank you very much. I know the commissioners are maybe less eager to interrupt than I am, so I will give the commissioners a chance to ask a couple of brief questions if they would like at this point, or you commissioners are also welcome to reserve. And no questions at this point?
I'll reserve my questions.
And that was who?
This is Commissioner Poma. I'm hesitant to ask, but one more, I just want to ask one. So on slide number 26, you're saying that Empire proved at the hearing that hydrocarbons from the ROS are economically recoverable. That is the rehearing brief. And then the second one, ROS in the EMSU sufficiently oil saturated to be recoverable through CO2 flooding. Now you're saying these are speculative assertions. Can you talk a little bit more about that? Because I disagree actually. So if you can explain that more.
Sure. So these are claims that Empire has made in its post-hearing briefing. Obviously, we spent nearly 3 weeks arduously arguing over whether this is the case or not. At the end of the day, the commission's findings in the order were that the ROZ has been proven not to be recoverable in either the San Andres or the Grayburg to date. There's a potential for recoverability, potentially, but as of right now, they have not met their burden to show that it is recoverable. We're living in a world where, unfortunately, we have deadlines and we have timeframes, and they did not meet their burden at the hearing. The clock has run. The game is up. Now, the commission always has continuing jurisdiction. And as we said at the close of the hearing, Empire, at any time, because it's a leasehold owner, it's an operator of a unit, can always come back and say, look, we've got new technology. We've been able to get a new additional information that was not available to us at the time of the hearing. And we can show now that this now is now potentially recoverable and economically so. But until they do so, and they haven't yet, there's no basis under the commission's ruling and order to hold that they have made that showing.
I'll reserve my further questions for now. Thank you.
Fair enough. Empire?
Thank you. May I approach with a handout?
Yes, that's fine.
If you could please identify yourself again.
Mr. Wheelmeyer will be speaking in a minute. I'll let him introduce himself in case I'm mispronouncing any names.
Thank you, Madam Court Reporter Corey Waymeyer for Empire. And on behalf of Empire, on behalf of William West and Mr. Lanning, we thank y'all for this opportunity to address you on this incredibly important issue. So we have the PowerPoint presentation. Chairman Chang, I really appreciate the questions that you directed to Mr. Rankin. I think we'll just actually go a little bit different direction. We've been accused of running from the findings that are contained in the commission's thoughtful order. And it's exactly contrary to that. We run precisely to those findings because all of those findings lead to the same result, which is that the new applications were correctly denied to prevent waste. The application to inject even more salt water in the Dawson was denied to prevent waste. And the suspension, immediate present tense suspension for the 4 existing SWDs was ordered to the ends of preventing waste. Now that also respects Empire's vested rights within the EMSU under the Statutory Unitization Act, as those are memorialized in the order from 1984 that this commission has repeatedly rejected Goodnight's efforts to set aside. So the theme that the theme that I
Somebody needs to mute their microphone.
Thank you. Appreciate it.
Yeah. Thank you. So the theme here that comes across has always been Empire running to the language in the statute, taking the statute exactly as it exists, living precisely within its rights that were vested in that 1984 unitization order, and embracing science and engineering to get to the right result. On the other side of that coin, you have the part of Goodnight who has repeatedly run from this 13-page order and the findings that are contained in it. They've stomped their feet, they fussed, they don't like it. because the order in its entire 13 pages all comes down to the theme of this commission's statutory obligation entrusted pursuant to the Constitution of the state of New Mexico to prevent waste. Now, the position that Goodnight urges here is a dangerous one. They would have this commission kneecap both it and OCD's jurisdiction by writing in this economic recoverability standard into statutes that the New Mexico legislature did not see fit to include. I'm going to go, instead of going through this PowerPoint, just to meet your questions head on, I want to go to the actual findings that after 18 days of testimony and 1.3 gigabytes or whatever it was of information that you get. Let's go to the actual order. So at page 1, if we go up to the top, the position that Rice and Permian and Goodnight urge here is that all this commission gets to do and all OCD gets to do is to address waste after it's already happened, and to completely throw out the window the prevention of waste, which is what's actually in the statute in the first place. So as we look at these Gooden, Hernandez, Hodges, and Sieber wells, the commission was acting correctly to deny those because you were within your statutory jurisdiction of preventing waste of the hydrocarbons that are both in the San Andres and the Grayburg, full stop, period. As we look at the Dawson, if you adopt this position that is wrongly urged by Goodnight and Rice and Permian, looking at the Dawson, you couldn't have done that. They would say you have to prove economic viability and economic recoverability, full stop, period, with direct evidence, or you've messed up on the Dawson. And the commission was acting exactly precisely within its jurisdictional mandate from the legislature when it denied the additional injection in the Dawson. As well as on the Piazza, the OCD found that it needed to prevent waste by denying the new Piazza application. This is not controversial. Of course, this commission, just as OCD says in its papers, there is no reason on this record to handicap your own jurisdiction to become the commission and the division that merely steps in after the waste of this state's natural resources already occurred, as opposed to preventing it before it happens. In all of this briefing that you've read, they do not have one single case that says prevention of waste equals mandatory proof of economic recoverability. Not one case, even stepping outside of the state of New Mexico to try to get to that result.
So let me ask a question, because it seems, again, the hard part that we struggle with up here, I think, is that both positions leads us potentially to a fairly extreme outcome. I mean, there's got to be a way for us to draw the line somewhere between whether or not you agree with that characterization. Mere bold speculation on the one hand that invites chaos to just anybody claiming they have a right with no evidentiary basis, right, or limited evidentiary basis. And on the other hand, certainly it seems like requiring a proof of actual recoverability also goes too far in the other end. How do we as a commission draw a line that doesn't invite chaos in either direction?
So, and I appreciate that question. And I think the answer is your 13-page order. Y'all sat through 18 days of patient testimony. You were more patient with me as counsel than you should have been. I own that and acknowledge that. You were more patient with our witnesses. But after all of that work, I read your 13-page order of trying to capture exactly what you just alluded to. Now, if Empire got to write this thing itself, its EMSU would have been permanently protected. It wouldn't have had a 3-year leash on the suspension, and it would have had certainty in terms of how it could develop its EMSU RAWS project going forward. We understand that y'all made that decision. That was within your jurisdiction to make the decision based on the extensive evidence. And I think your 13-page order hits precisely the balance that you just alluded to. If in 3 years we're not back to you with evidence that is satisfactory to the commission, then at that point, the suspension, not permanent revocation, can resume. And that's what the order says. The order actually says we're to be back in 3 years with additional evidence to report to you. What do we find in core? What have we found in admissibility studies? And so I guess to your question, the 13-page order couldn't have done that more perfectly. It's not what Empire would love. of course. Our rehearing was denied. I understand that and we respect that, but it's where we're at. But I want to, again, since we've been accused of running from this verbiage, we run straight to the findings that this commission thoughtfully made. And if we can just scroll down at 2A on page 5 of 13. In our opinion, this should be the end of it. Based on the 1984 commission order, and Goodnight has challenged this thing over and over and over. They don't like what happened nearly 40 years ago. But under that order, Empire owns, it paid millions of dollars to XTO, the exclusive right to produce the RAWs in the EMSU, full stop period. There's 3 separate bases for denying this rehearing that's been asked for. One of them is under the Statutory Unitization Act. Units don't mean it. As I talk about this being a dangerous approach that's urged over here, not to the ends of any good policy for the commission or the district. It's just a position urged to further the economic ends of companies in Fort Worth, Texas, and Dallas, Texas. That's why they're advocating it. It's not out of any concern for the state's natural resources or policy here. They would say we can blow open all the units, and they will cite this order. If this order gets changed, they will cite the order as evidence that you can put SWDs into somebody's producing unit that's been established under the Statutory Unitization Act. That's dangerous. It's unnecessary. It's out of step with the statute. The commission has that exactly right as it writes about it here.
Okay, so but let me drill down a little bit more because people use our orders as precedent, whether we like it or not. So how do I draw the line? What standard of proof? So do we need to draw here or do we need to clarify so that we don't have merely bald assertions and without any sort of proof? Because we could be opening the door to all sorts of chaos if anybody could make a bare allegation and shut down other people's at least what they perceive to be validly obtained permits.
And Dr. Ampoma has this exactly right. I think it's offensive to this commission after all the thoughtful work it did and the careful attention it paid to the proceeding to call this a bald assertion. And as you return to the actual verbiage, there are no bald assertions in here. Let's just take the actual findings that the commission has already made. And to do that, we'll go to paragraph B and we'll start at 28. So again, we talked about RAWs. Steve Meltzer talked about what is a RAWs. RAWs are 20-ish% or more consistent oil saturations. The oil is there. And the idea that this is a bald assertion that there's oil there, with the finding of a RAWs, you get with that the cookbook, and you get with that Mr. Meltzer's description of exactly what that is. And if you recall back to Mr. Macbeth's calculations and the calculations done by Mr. Davidson and Mr. Knights, Dr. Davidson and Mr. Knights, under their work, there is vast volumes of oil there. Nobody can question that there's vast volumes of oil in the San Andreas that are going to be forever locked in. They try to couch this as, well, it's just an economic question, but you can look at Mr. Macbeth, Mr. Knights, Dr. Davidson, and it is monstrous volumes of oil that are in the San Andreas, even believing them. Obviously, our volumes are different, but you can take them at their word. There's oil, and it's not only Empire's oil, it's the state of New Mexico's oil, it's the United States oil. That's not bald assertions. That's straight out of their experts' mouth. But as we continue on, at paragraph 30, one slide showed pictures with core samples. So this is hard, direct data, came straight out of the earth. We actually brought in the core so you could smell it, you could touch it. And those saturations were between 19% and 38%, right here in the San Andreas that Goodnight is destroying to further the economic ends of companies in Dallas and Fort Worth. That's not speculation, Chairman Chang. That's direct evidence that you can't argue with. Continuing this, running to the language of the commission's order, let's go to slide 30, paragraph 36. This is not taking my word for it. This is not bald assertions. The commission found that Goodnight's own witnesses, Dr. Davidson, Mr. Knights, Dr. Lake, and Mr. Tomastic, agreed that a RAWs exists. And the commission cited back to that. So when counsel suggests, no, there's no RAWs here and we never agreed there's a RAWs, The commission expressly found in its fact finding that their own experts conceded this fact. This is based off of core, it's based off of petrophysics, off of geologic models, off of engineering models. At 37, this should be enough, and this, as we talk about, this isn't the exact order we would have loved if we'd have gotten the chance to write it ourselves. But here at 37, this is dispositive. Dr. Davidson, this is Goodnight's witness, confirmed that oil saturation exists throughout the San Andres, stating, quote, there's some up to 30 to 40% in there. They show up periodically up and down the system. So yes, there's oil down in there. 30 to 40%. And it's been said that there's never been a drop of oil produced. The evidence is actually completely counter to that. There were 7 barrels of movable oil. So this is past RAS. There were 7 barrels of oil that swabbed up. This is in the record. It's uncontested. It's in the records. For that oil to move, you've got to be at high saturations. No speculation. The oil is there, and this commission has already found it's there and has noted that out of their own expert's mouth that these saturation 30 to 40%.
There's no debate for me on that point. And so I will, just as I pushed Mr. Rankin to maybe wrestle with some of the findings that are more difficult for him, I'll push, how do you wrestle with the fact that the commission found that whatever RAS we determined to exist, or the commission previously had determined to exist, hasn't been demonstrated to be recoverable? How do we get to exercise our authorities to prevent waste when we haven't made a finding that there is a recoverable resource? I mean, if it's not recoverable, without the finding that it can be recovered, there also isn't a finding, I guess, that there is anything to waste, isn't there? Like, how do you respond to that point from Mr. Rankin?
The statute doesn't say that. What the statute speaks to is prevention of waste. If we're back to the Oil and Gas Act, it doesn't speak in terms of recoverability, and they don't have a Supreme Court case or any other case that speaks to this arbitrary recoverability. And they've cherry picked state. They showed 2 of them in there. Empire's had fight after fight on this concept of economic recoverability, and that's not in the statute. That's nothing that we've ever conceded or agreed to. But it gets easier. I'll hit these little points here, and then I'm going to get to the easy button on all of this. Because again, I come back to what the commission's charge here is prevention of waste, not after it's already occurred. If the rule and if the law in New Mexico is as Mr. Rankin and Goodnight urges, there would be zero exploration. It would be a situation that unless you can until you bring and prove recoverability, you can inject waste anywhere you want in this state into anybody's minerals, into anybody's unit. That is not what the legislature charged this commission with. It was to step in based on the totality of the evidence and assess, is this a situation where waste needs to be prevented? And what the commission did in what I say is the middle ground here with its 13-page order, they said, we're not permanently revoking the permits. We're not permanently revoking them. What we are doing is allowing a 3-year window to determine this recoverability issue, to bring back the evidence, which is consistent with our ownership of the EMSU and the exclusive rights that go with it. Now, if this injection is not suspended under the commission's own findings here, the RAS and Empire's rights are completely and forever condemned. At paragraph 40, the commission found that the Goodnight 6 applications must be denied because the injection of hundreds of thousands of barrels a day conflicts with Empire's exclusive rights to extract oil in the EMSU in order to perform a successful CO2 flood EOR project. The injection of CO2 and water must be monitored closely and adjustments made based on design. Goodnight's SWD wells cannot dispose of water when Empire's active CO2 flood is being performed without adversely affecting economics. So we know, without changing any fact findings, we know that these 2 things, injection and development of an EOR or even execution of a pilot, cannot coexist. We don't have to have new fact finding. We don't run from the fact finding. It's right here in black and white. But coming back to just the easy button on this, here's the easy button. 3A. So they hide from the regulation and rulemaking that says if the water can escape the zone or is escaping the zone, that all by itself, we don't even have to play the recoverability, economic recoverability game that they try to play, rewriting the statute and creating cases that don't say that. This is the easy button and we're done, because the regulation is perfectly clear. If it's not confined to the zone, the injection must stop. And that's been briefed to death. But here's the fact finding that went with it. We know that the Grayberg is economically recoverable because right at this moment, the Grayberg is being economically recovered as part of secondary operations. We know that. We know the Grayberg is above the San Andres, which is where they're injecting the salt water. And without changing any fact findings whatsoever, at paragraph 47, this commission has found, this is an established fact. Empire's witness, Dr. Buckwalter, built a model, and the model shows to a reasonable degree that water is moving from the San Andreas into the Grayberg. This could lead to communication between the Grayberg and San Andreas. So with nothing but the regulation on the requirement that this be confined to the injection interval, here San Andreas, and this finding that we have shown as a matter of proof here to a reasonable degree that water is moving from San Andreas to Grayberg, we're finished. And that is absolutely consistent with this commission's charge to prevent waste. That is, don't let the waste in the Grayberg happen in the future, to suspend it right now while we collect additional data. But again, the easy button here, we don't have to make a sweeping, you don't have to write this crazy economic recoverability into the statute that the legislature didn't put there. Paragraph 47 all by itself, it consistent with the regulation on confining to the zone is there. Additionally, the commission's going to remember well that this was never Goodnight testified to you that this was never about seeing where the science and the engineering went. It was all about trying to get back to the result of their economic ends. They didn't map any continuous barrier that would confine the liquids to the injection zone. They told you that they saw their role as merely throwing rocks at what Empire did. With the last 2 minutes I have here, I wanted to address the question too.
Please.
Please, if that pleases the commission. So question 2 was, what does OCD get to do here? And when the order says suspends, present tense, what nobody has cited is any prior case or any case law or any division action or any commission action in which a permit was full stop suspended, but that some waste was allowed to continue, some injection was allowed to continue. Suspend, present tense means suspend.
Could we scroll down to that paragraph? Because council, doesn't that paragraph also say in order to provide an opportunity, actually, let's see, we might have just, I'm not sure exactly which paragraph it was anymore, but I believe it also says in the order that that the suspension is in order to provide Empire with an opportunity to establish CO2 EOR project. Doesn't it?
That's exactly correct. And this dovetails with the finding in paragraph 40 that the commission made. The two cannot coexist in terms of measuring the pressures, in terms of monitoring the water. And we haven't even talked about the chemical incompatibility of the different waters and the water compatibility aspects of all of this. But it needs to stop. We only have 3 years. So Mr. Wheeler's testimony was cited as part of the 3-year piece as saying that's an amount of time. In terms of how and when that goes forward, of course, we agree OCD has to permit the process, has to review the process. We did not take this order as a carte blanche to go out and just start drilling holes in the ground without OCD's oversight and input. But as a practical matter, 3 years in the confines here will be difficult enough without having continued injection into it right now. There was tons of testimony about the increasing pressure. Goodnight's not going to disagree that the pressure is increasing. It's been seen in the tests they filed back with the commission. If it's stopped for 3 years, Empire can get this done, and we're going to come back and show the commission that this is a wonderful success case, a wonderful raw success example for the state of New Mexico, its minerals, its people, the BLM, and for Empire's shareholders.
Now, I don't happen to know off the top of my head whether or not, where you are in your processing, in your permitting process, but for the sake of argument, let's say that you still have permitting to do. How do we wrestle with the words "in order to"? Doesn't those three words "in order to" provide OCD with the capacity to tailor the suspension to only the scope as necessary for a CO2 injection? And of course, it wouldn't be necessary until, or do you dispute that the suspension wouldn't be necessary until you have a project ready to actually conduct with all the permits in place and all the drilling done?
Absolutely. So suspends is present tense. All of the testimony is that it has to stop the injection before we can go forward. The harm is absolutely occurring. I'm not fussing with the commission's finding, but this is moving to the place that Humpty Dumpty can't be put back together again in terms of these volumes. Pressure's rising, the volumes are there, the water incompatibility is there. It says suspends present tense. This is all to the ends of allowing us to go forward with the pilot. And so I think that the position that we've urged is absolutely consistent. OCD's frontline position and the briefing that it's done is that this should be implemented over 30 to 90 days, the suspension. That was the frontline position, followed by, in the alternative, we would get into this, try to figure out how the two of them work together. These parties are not going to work together. I mean, we certainly can agree on one thing in here. This is, Goodnight will do everything it can to make sure that this is the most miserable failure for Empire that it possibly can. They want this to be a trash disposal site. There's no two ways about this.
I'll ask you to avoid the personal. I'm sure you guys can find a way to get along, at least inside this community, this hearing room. Your time is about up. So in fact, I'd like to turn or I'll give you briefly, if you want to, just 1 minute to sum up your sort of highlight reel, and then I'll turn to the commissioners for any additional questions.
Absolutely. I guess the sum up on just that last piece, in our briefing, we identified what would be reasonable benchmarks in terms of implementation of the pilot. But again, this is all against the backdrop of right now, the water injection by the commission's findings is not being confined to the injection zone. To not immediately suspend based on the finding that it's not being confined to the injection zone threatens the Grayberg, and it does not honor the commission's duty to prevent future waste in the Grayberg when we know, based on the finding here, it's not being confined. Of course, if there's any questions, I'd be very happy to.
Commissioners, I'll open the floor for any questions.
Thank you, Mr. Chair. I do have, this Commissioner Apoma, I do have a question. So let's take it this way. The sentiments of the public. Now, so on that question, normally I want to move out from the scientific world to come to more or less like a real case, real world scenario. So assuming, or let's say based on the information that Goodnight submitted to the commission, it's more like their injection is supporting about 30,000 barrels of oil production. So from public point of view, they are really interested in their 30,000 barrels of oil. Now, how do we square that? Well, let's say Empire is probably going to take about 2 years to more or less go in there and actually start the pilot project itself. We are canceling permits to suspend, or let's say even we don't know the uncertainties associated with the 30,000 barrels of oil tied to the injection. Whereas you are spending about 2 years doing, still preparing and not doing the actual pilot. So could there not be a situation where, because of the public 30,000 barrels a day, there could be a way that OCD can structure when to suspend all the injection, to make sure that we do see actual CO2 project, and then we do see a suspension because they cannot coexist, like you said.
Well, thank you. And I appreciate the confirmation that they can't coexist, because as we read this, there's just, and also our witnesses testified, there's no way these can coexist. What I would say first is that the idea of balancing public interest That's not in the statutory charge that the legislature's given you in terms of these operators outside the unit are going to make more money, and so we should hurt Empire inside the unit. So first, I would say there's not a statutory basis for this weighing exercise in terms of the three separate statutory bases that we brief out. The second piece is that the actual evidence that was adduced didn't find that if this injection is shut in, it would affect any other operator. And that's also not in the commission's fact finding, that the idea that if these wells are shut in, something bad happens somewhere else. Third, again, we have pre-existing secondary production in the Grayburg right now, and the commission's made the finding it's not being confined to the injection zone. I think the public, and I understand you're referring to the operating public with that question. The public, being the citizens on the street, would be outraged to learn that the commission allowed a situation where there's not a confinement of fluids to the injection zone. So I think that public needs to be considered here as well, in addition to their rights. But again, 3 years is not a long time. In terms of getting going on the project and executing it, again, these pressures are rising. I mean, this is just a basic matter of engineering, that the pressures will rise with every barrel. And Commissioner Ampoma, I would come back to the findings earlier in here that you noted, the commission noted, injecting these tens of thousands or hundreds of thousands of barrels every single day is not only inconsistent with Empire's pre-existing invested rights, it's also going to leave this rosin into a place that, as a matter of economics and feasibility, just cannot be developed if it continues.
So is it your assertion that there's no way that both parties can really discuss about the suspension timeline? There's no way.
So OCD's weighed in on the suspension timeline. We've now weighed in on the timeline, and Goodnight has weighed in on the timeline. Again, I read OCD's frontline position as being this is a 30 to 90 days, or in the alternative, we've said we can live with 30 days. But the idea that you can go forward while it's happening, I don't think that's feasible at all. And one, they didn't have any testimony at the underlying hearing that could suggest in a technical way that could happen. Second, what you heard from Mr. Burkhead in his testimony was that they literally put these SWDs on the best rock. So when you look at the structure and you look at where the SWDs that we're fussing about are located, they are smack dab where the pilot would likely be executed, which is and that testimony is in the record. Had this been way up on the northwest corner, or if the SWDs were some way up on the northwest, maybe this is something we can talk about. They stuck it right on the best structure, right on the best rock, right exactly where the pilot would be executed.
Any further questions, maybe from Commissioner Lemkin, or would you like to reserve your questions? Any further questions at this point? This is Commissioner Chang.
No questions from Commissioner Lampkin.
Thank you. Thank you very much. Next up will be OCD. However, if for the convenience of the chair to use the restroom, I propose a brief break. If we could please return at 2:45, that'd be very much appreciated. Thank you.
Court reporters present and ready.
Thank you very much. We might, are we missing anybody? No? Are we all back? Oh, yeah. Is Commissioner Lampkin, are you online? And Mr. Suazo, are you online and ready to proceed?
Yes, I'm
Commissioner
online.
Lampkin here.
Right. For the court reporter, both Commissioner Lampkin and Counsel Suazo are both with us and present. So everybody being present and accounted for. We resume the proceedings and I invite OCD to present their arguments. Just for my timekeeping, Counsel, how much time would you like to reserve for rebuttal?
Mr. Chair, why don't we say 7 minutes, if that's okay?
That's just fine. All right, I will. That makes the math more difficult than I want it to be, but fine. I will start your time. Go ahead.
Mr. Chair, Commissioners, thank you for the opportunity to provide a little oral argument today. Stepping back, I wanted to reframe or frame up again OCD's involvement in these various cases. It originally started out as an issue of OCD seeking to protect sources of underground drinking water per the Safe Drinking Water Act. And OCD had one plan that was put into play or intended to be put into place. We obviously withdrew from the case, but then had the pleasure of re-entry. And the simple reason for that is OCD had some concerns about Order 24004. Those two concerns, simplified, but will be addressed a little further down the road here, were the issue of suspension. And OCD has provided quite a bit of information on how OCD traditionally approaches suspensions, that it's rather rare to have an immediate suspension. Shut-ins are one thing, but suspensions are quite another. And then the other aspect being the order from OCD's perspective, which will also be addressed a bit further in this discussion, about how to supervise the Empire's proposed EOR project. Turning to the actual key points here is the OCC, from OCD's perspective, has authority to suspend permits. To be unequivocally clear here, OCD has not taken a position on the topic of recoverability or paying quantities and won't address that today any more than it's addressed it in the past. OCD sees that as a dispute between two operators and their burdens of proof and quantums of evidence. Turning first to Goodnight and Rice, as noted, OCD doesn't have a position on the recoverability and paying quantities issue, but both parties agree, stands that issue, that the OCD does have broad and deep authority that ultimately the OCC can in fact suspend permits and can in fact permit EOR pilot projects to proceed. So OCD doesn't have any particular quibble with either of those parties on the topics presented. Now, Empire is a slightly different story. There's been a lot of shifting positions, interesting, innovative theories here. Up until these issues were presented, the two questions before the OCD or the OCC, Empire hadn't had any real comments on authority, but through various pleadings, Empire states it doesn't object to OCD authority to regulate suspensions or the EOR projects. Now, they've got specific complaints about the suspensions, which will be discussed here briefly. Heading to the pleadings directly, and then I'll address commentary argued today. Regarding the EOR project, Empire's argued that OCD's plan is premature. That's a direct quote. That OCD's plan to regulate this project is way too ahead of the game. OCD disagrees rather vehemently about that position. Empire and their counsel have stood before this commission and insisted they are ready to go. They are prepared. Now, what their excuse will be here is, but not until Goodnight suspends its injection. That's a curious position, given that Empire hasn't communicated, to the best of council's knowledge, with the OCD about any of these intentions. And OCD would take that as an indication Empire never had any intention of following OCD's regulations. Rather, they were going to wave around a carte blanche in the form of, the OCC said we have 3 years to do whatever we feel we need to do. That's quite frankly absurd, given what the promises that are being made for the good people of New Mexico. Oh, and before I proceed any further, just as a point of order and of the record, OCD is going to move the commission to take judicial notice that Empire's corporate headquarters are in Tulsa, Oklahoma, as reflected on empirepetroleumcorp.com as of today. And would like that just at the very minimum noted in the record, especially given all the criticisms of those Dallas and Houston oil and gas companies. In New Mexico, it is pretty open season on us from.
We're not going to weigh in on whether Tulsa is any nicer than Dallas.
And that's fine, Mr. Chair. Suffice to say that all parties in this case aren't exactly local yokels. Now, turning back to what OCD originally proposed for the EOR project, there's Empire, again, has claimed it's ready to proceed, and then now essentially is contending it absolutely can't. It's ready to proceed was an evidentiary issue, and now it's contention that it isn't is starting to turn into just mere argument. What OCD has proposed is, and the term, actually, I'll find it here, in OCD's brief that was filed on October 31st, the opening brief is ordered by the commission. OCD specifically says it's an EOR project, and that the project itself, this is all part of it. And so OCD absolutely contemplated that this was not the EOR procedure in and of itself, but that this is a continuum of things that's going to need to be addressed. OCD's main concern here, and the reason why OCD is seeking guardrails as to Empire, is because the OCD is aware of a habit of parking properties, rights, et cetera, and sitting on them until the last minute for economic tactical purposes. There's no evidence that's necessarily happening here, but OCD does tend to be proactive about that and ferret it out when it thinks it's going on. And there's a potential for that here. Something else, though, is Empire's really pushed this immediate suspension thing. And that's a reflection that Empire doesn't care, one, about the safety and the process of suspension. They don't care whatsoever. They just want it shut down now, which is a problem from OCD's perspective, because part of what it does is it does actually look out to make sure these processes are done in a way that's safe for operators. Now, that's all curious because, again, we have the swearing up and down that they're ready to go, but they resist OCD's proposal, which is fairly straightforward and holds them to account. And secondly, Empire misstates its position today. It had no intention of complying with the old regs, and that's proven by the lack of filings, communication, notification. Now, briefly touching one more time on Goodnight, what OCD has proposed is the alternative option, that there be 30, 60 day or 30, 60, 90 day benchmarks for the wind down, which OCD does think is appropriate. That's what it usually does when it suspends things, to ensure the well has been mechanically shut down in a proper fashion and there's been no undue risk to employees and other operators. But additionally, that OCD is not going to weigh in on whether it's an either or issue between injection of produced water and injection of CO2. But if the commission were to find it appropriate and conclude that Empire is in fact not ready to proceed with the EOR pilot project, then it would make sense to have a tiered situation. And while the parties may not get along, and that's something that the OCD has not been involved in, notification OCD certainly would simplify that equation as the regulator. And at that point, what would amount to a third party neutral that would be enforcing its own regulations.
So let me push on that just a little bit more and seek some clarification. It seems like from the filings, everybody says in some version that OCD possess broad regulatory powers. Everybody says that in some form or fashion, whether or not they feel the need to then add some qualifications to it. Now, and OCD, as I understand it, re-entered to seek guidance or clarification on what the commission intended with suspension, present tense, as we've been urged. And so the same question that I asked earlier about the words "in order to," doesn't the words "in order to" provide Empire with the opportunity to conduct a pilot project? Doesn't that provide some guidance to OCD? I understand that OCD has laid out some of its, typical, well, unfortunately, as OCD laid out, there's nothing particularly typical about this particular case. And so I guess, isn't the fact that the commission ordered the suspension in order to provide the pilot project sufficient guidance for OCD's technical staff experts who would be in the best position on determining how to organize an orderly suspension to the extent necessary and therefore in order to facilitate a pilot project?
Mr. Chair, in a broad sense, yes, but there's a comma and a but. The way OCD suspension program, the way it operates with suspensions is in a pretty narrowly tailored regulatory environment. And this case arguably lacks about everything you'd see in that case, absent the fact there's been a full hearing, a full opportunity for parties to present evidence. OCD didn't avail itself of that, which I'd be foolish not to acknowledge. We could have been involved in that. We chose not to be. But because of that, we wanted more clarity on what the OCC actually wants this done in terms of sequence. Because if we take our enforcement protocols, then we would be looking at a 30, 60, 90-day process, which will clearly upset Empire and probably cause us to revisit this stuff all over again in some way, shape, or form, barring an appeal perhaps. But that's why OCD wants at least some, I don't want to call it like surety or anything, but it wants clarification on what's the intention here. Is this a strict, okay, these permits are suspended and here's the OCD, proceed along your traditional process? Or is it OCD, you need to proceed along as a suspension followed by an abbreviated process? So we understand exactly how the OCC wants us to go about that.
But given again that all parties agree that OCD has broad discretion here, why shouldn't the commission simply leave this to the technical expertise of the division to figure out what is the most appropriate under the circumstances?
And the OCC is absolutely free to do so, and the OCD would, of course, comply. But again, OCD is being cautious here, given the rather aggressive nature of this litigation and the parties, and making sure that it is doing all that it can to properly observe the intentions of the OCC. And so with that, I'll stand for any additional questions. Otherwise, I'll pass the microphone.
Any questions from commissioners?
Yes, I do. So when a quick question for you, based on your submission, it sounds like you believe that there has to be some direct benchmarks attached to the CO2 UR project to just leave it for 3 years. Can you comment on that?
Yes, Commissioner Mpoma. So the concern here is that Empire's now received a 3-year window to establish its EOR pilot project. There were no other constraints placed upon Empire. There were no limitations, deadlines, or even expectations other than the sole issue of a return date in 3 years to theoretically prove up that this EOR operation has a future. The issue with that is that leaves a lot of things unaddressed. And that starts, first of all, with a review of what this project even looks like. From OCD's perspective, there was a variety of evidence put in during the course of the hearing, but that is not necessarily how OCD is going to look at these applications. That tends to be a discussion process where the application, or at least an initial submittal saying, here's what we're intending to do, we'd like to discuss it with you, flesh out problems that OCD may identify, and this is not in any way a judgment on the OCC, but that's a level of critique and analysis that isn't likely to be rendered in these hearings. And that's where OCD's expertise comes into play. And then after that point in time, there needs to be some pushing of this project to ensure it's actually completed. Because the other side of this is, when we talk about waste, is that if Empire fumbles this, and let's just say 3 years later, Empire comes back and says, oops, we did fumble this, then there's a lingering question of whether waste actually occurred during that period, because parties that wish to inject have not been allowed to do so. And so OCD foresees that, to use a legal term of art, the parade of horribles that can come from some of these things, where there's a sequelae, a series of first, second, third, fourth order effects of a particular legal determination that may not be factored in. And this is OCD's attempt to try to forestall that, prevent it, frankly, and to make sure that Empire is held accountable for the grandiose promises that were made to the people of New Mexico and this commission. They were big promises. And let's see if that's true. And we'll encourage and help and make sure that process proceeds.
Any further questions from either, if it doesn't sound like Commissioner Mpoma has any further questions. What about Commissioner Lemkin? Any questions, or would you like to reserve at this time?
Yeah, I'll reserve my questions. Thank you.
Thank you. Appreciate it. Well, thank you very much. In that case, we will turn to arguments from Pilot. I'm sorry, from Rice, I believe.
It's all right with me if Pilot goes first, but I'll go. Madam Court Reporter, this is Matt Beck for Rice and Permian.
Thank you.
Chair, you asked a question which I think is very important, which is whether the possibility of recovery at some point is sufficient to suspend Goodnight's injection wells. And I think on that question, Counsel for Empire says that Rice and Goodnight are asking the commission to set a dangerous precedent here, one that would, quote, kneecap the jurisdiction of the commission. And that's not at all the case from Rice's standpoint. What Rice has pointed out is that that jurisdictional limit is provided in the Oil and Gas Act. It's provided in the statute that creates the commission, and it's recognized by the Supreme Court in the Continental Oil case and Sims against Meacham. And so in the context of a court case, it is almost every single time that when a court enters a judgment, the parties ask for rehearing, retrial, reconsideration of that judgment to inform the court why they believe the court may have erred, to prevent it from coming back down from appeal. And this process is very much like that. It's a rehearing from the commission asking what was wrong with our order and what happened. What did we do? And the commission limited that inquiry to two narrow legal issues. Now, as I said at the beginning, your question whether the possibility of recovery is sufficient is the most important one, because it is not. The commission is limited to prohibiting waste. And we've talked a lot and we've heard a lot about what waste is, but I think the most important is for the commission to look at what the statute says. Now, obviously here we're concerned with underground waste. We're not concerned with the first part of that, which is the inefficient, excessive, or proper use or dissipation of the reservoir energy, but we're concerned with the second part, which is the locating, spacing, drilling, equipping, operating, or producing of any well or wells in a manner to reduce or tend to reduce the total quantity of crude petroleum oil or natural gas ultimately recovered from any pool. and the use of inefficient underground storage of natural gas. Now, if that said instead, that reduces or tends to reduce the total quantity of crude petroleum oil or natural gas possibly recovered, that would be critical. But it doesn't. It says ultimately, which is why, as Rice pointed out, the fundamental problem with the commission exercising its jurisdiction to suspend a permit after its finding is error. It does not have jurisdiction to exercise that with the word ultimately recovered there.
Thank you, counsel. I'm going to jump in here because all parties, all parties cite to this particular definition, and it seems like you all simply highlight or emphasize different parts of this definition. And this is why we wanted to make sure, or at least I pushed for us to have this hearing, partly because to explore exactly the disagreement here so that we can build a sufficient record, because I have no doubt that some court is going to have to review our homework here. But if you look at the word here, as you've pulled up, isn't the word tend a probabilistic word there? Tend to reduce?
Sure.
I mean, not proven to reduce, but tend to reduce?
Sure. And there are multiple ways in which it could tend to reduce the ultimate hydrocarbons recovered. But
So is that enough then to define waste? And not beyond the word tend to, you also looked at the word ultimate recovery, isn't that right? Yeah, ultimately. Ultimately, I mean, that doesn't mean proven to have been recovered today, right? Isn't that also a future predictive sort of word?
It is completely. And that's why you have to have evidence that the hydrocarbons are recoverable, which was not presented in this hearing. And it could be at some point in the future, right? If you look at Empire's response brief,
I would find it very, I would find the arguments that that Rice and Goodnight makes much easier to follow had the commission gone as far as to find that there was sufficient evidence to prove that the reserve is not recoverable. But that's not what, in fact, we found. So I'm left again with, we don't know either way. The commission did not, in fact, find that it's not recoverable. So what do I do now with there's no evidence either way?
There has to be evidence. You cannot say that the absence of evidence proves ultimate recovery. That is not the definition of proof, which is a preponderance of the evidence, which is 50% or more. And this goes back to the very beginning in this hearing process when we delineated who has the burden of proof to prove what. And so you cannot say because there is equal evidence on both sides or we didn't make a finding that we have jurisdiction. That's exactly what the Supreme Court has said in these two cases, Sims and Continental Oil, is that you have to have, they reversed in Continental Oil and found invalid and void two commission orders that, quote, lacked the basic findings necessary to and upon which jurisdiction depended. That's paragraph 20 of that case. There has to be a finding. You cannot say that the lack of a finding makes a possibility. And this gets into the second point you pointed out, which is the ROZ sufficient? We found an ROZ. Is that sufficient? And it is not. It is not sufficient because there are no cores that show that it may be recovered. We don't know the amounts, but more importantly, we don't know if it's physically recoverable. So as I said, when you go to Empire's brief on rehearing, the first point there is that the ROZ is recoverable, arguing with the facts. If you look at the footnote in their brief, it points to, and sorry, I don't have this on my computer or I would show it to you. But if you look at the footnote, I can't read the number. It looks like footnote 3 on page 3 of their brief. They cite to transcript hearings saying that even Goodnight's witnesses agree with them. Well, if you go to the actual transcript of Mr. Macbeth and Mr. Waymeyer, he asks, look at the oil in place volumes. You didn't calculate under 20%. You don't know one way or the other whether that would be recoverable. Mr. McBeath, I don't know, no. Mr. Waymire, if it was excluded, you would agree that some of that oil in the EOR is actually going to be recovered here, wouldn't it? Mr. Macbeth, what oil are we talking about? Question, oil that would be between 0 and 20%, but some of those volumes would be recovered. Answer, depends on if you could efficiently and effectively contact it with CO2. He says there are no miscibility studies that show that. I don't know what a miscibility study is, but I assume it would show whether you could contact it with CO2, which gets into the OCD's point about where we stand in this, that there is no application. Where would we find the answer whether the oil in the RAS is recoverable? I assume we would find it in the application for a pilot project, because if we take a step back here, this whole case is based on the idea that water injected by Goodnight is not confined to the injection layer, right? And if water is not confined, how is CO2 confined? I expect we would find that answer in their application for a pilot project, how they intend to confine CO2 and move oil that by definition is not movable by oil. But we don't have that information. It's very possible that when they look at this project, they will actually say, you know what? There is a confining layer down there. We're not going to try to get out the oil in the RAS from below the confining layer in the San Andreas. We found that that existed. And in that case, just as was pointed out a moment ago, now we've come to waste because we've suspended Goodnight's injection prematurely because those hydrocarbons cannot be recovered, which circles back to the definition that there must be a finding of recoverable hydrocarbons for the commission to exercise its jurisdiction. And that may happen at any point. It could happen a year from now, it could happen 3 years from now, it could happen 10 years from now. It can happen when there's evidence in the Supreme Court's language sufficient to make that jurisdictional finding.
If we adopted that view, though, setting aside the legal authorities question for a second, wouldn't there be policy implications there to limit or discourage or chill the potential of exploration? Because it seems like if the argument is that it needs to have been proven in order for people to do pilot projects, or in order for people to get out there and try to explore, wouldn't there be a policy concern that taking that line would chill exploration for oil and gas in the state?
No, Chairman, respectfully, no, because that's the definition of waste. That's the whole way this system operates and has operated since the introduction of the Oil and Gas Act, is there has to be recoverable oil. And so when they go and they test and they drill a well to test, they're testing for that recoverable oil. And if it's not there and it's not economic, then they don't do anything else. That's why there are penalties, non-consent penalties in pooling orders, because you might test and find a dry well.
But isn't that the problem here, though, is that if we were to side with Goodnight and Rice here, we would be preventing the exploration. We would be preventing a pilot project from doing that exploration that you just mentioned, that one would have to do exploration to determine recoverability.
Sure. Chair, I appreciate the question, and the answer is no. Empire, I believe in February or March or January or whatever, applied to do, I think, 3 or 4 test wells in the EMSU so that they could take core and they could take sponge core and they could take the other kinds of core that I wouldn't know unless I had them in front of me, and I still wouldn't know what that means. But they are doing those tests for the purpose of coming up with evidence to see whether there is oil that is recoverable in the ROZ. I expect to use in their application to then go and drill the pilot project. And again, we circle back to the definition of an ROZ here, which is that it is not mobile with water. And so the water being injected right now, today, by Goodnight is not affecting the ROZ. It has been in place for years and years, and it will continue to be in place. There's no evidence of that. What Empire pointed to a moment ago was pressures. And if you look, one thing that they left out when they're running to the findings is the finding that the commission made in its order under its finding in C that there's not evidence that their rights in the Grayburg are being impaired. In paragraph 56, the strongest evidence for no communication currently between the San Andreas and Grayburg is material balance, which is volumes and pressure, and the limited change in pressures in the San Andreas for the volumes of water that were both extracted and injected, quote, is just amazing, quote, in a unique situation, which is showing that by not approving the new well applications, the commission exercised its duty to prevent operations that tend to reduce the ultimate amount recovered, because the evidence in the hearing was all based on the, if we go back, all of the models, all of the evidence from Empire was based on the approval of these wells for additional hundreds of thousands of barrels of salt water a day. The commission exercised its discretion to prevent what tends to reduce the ultimate recoverability by denying those applications for additional wells. And what it leaves in place is, quote, a just amazing reservoir in the lower San Andreas that everyone agreed was basically unbounded and inexplicable. And so the commission's order is entirely consistent with preventing underground waste that tends to reduce the amount ultimately recovered when it denied the applications for additional wells and additional drilling authority. When it found that it was not proven that any oil in the ROZ is recoverable, that finding under the Oil and Gas Act, as recognized by the Supreme Court, for lack of a better word, magic words that prevent the commission from exercising its jurisdiction to suspend the wells unless and until Empire comes back and can prove that that oil in the ROZ is recoverable. And then turning to the second question, which I agree with, again, with what you said, Chair. I think everyone's on the same page, that as you pointed out, the order does not say suspends, quote, full stop. And I'm glad you caught that, because it says in order to provide Empire with the opportunity to establish the CO2 EOR pilot project. As the OCD points out, that may never come to pass. And if it doesn't, then faithful execution of this order is not to suspend Goodnight's wells. Because again, they are not upsetting any oil. It is a ROZ, by definition, immobile by water. And so in order to use plain logical language, if Empire comes up with a CO2 EOR project that the division approves, then the division can suspend Goodnight's injection wells to faithfully implement the order.
Anything further, council? Or are you ready for questions from commissioners?
Oh, that's it. I'm ready for questions. I was trying to work in sequelae because I really like that word, but I couldn't fit it in.
Fair enough. Any questions, commissioners?
Yes, I do. So Commissioner Mpoma here. So Mr. Beck, you agree that once CO2 EOR project starts, there could not be saltwater injection into the same zone?
I haven't thought a lot about that, but I mean, I think the commission already found that, right? I think that's in the order. I've made it a point to follow the commission's order, not to argue with you on that, and I'm not going to start now.
So from your point of view, so it sounds like you're saying that based on the order, it is tied to suspend injection to allow your project. So it's more or less connected to each other. So without an approved CO2 EOR pilot project order, you believe that the burden has not been reached to suspend the injection?
Chair, Commissioner, with respect to that question, taking that as itself, again, I don't think the commission has jurisdiction to do that. But if it did, looking at that second part of the order, yeah, I believe the order is clear that it suspends it in order to allow the CO2 EOR project. My understanding, until Empire has approval to do that EOR pilot project, it can't move forward. Once it does, if that happens, then the OCD shall implement the order by suspending Goodnight's injection wells. And I agreed with the chair, and I think OCD has the expertise to do that efficiently and effectively and within its statutory bounds of preventing waste.
So it sounds to me that you are in line with OCD's second suggestion with regards to the curtailment of the suspension, not straight away 90 days, but just tied to the CO2 UR project.
Chair, Commissioner, yes. And again, I mean, that if we just take a step back, it makes total sense when we're looking at an ROZ.
Thank you.
Commissioner Lemkin, any questions for this particular attorney? Or party?
Commissioner Ampema covered my questions. Thank you.
Great. I will now turn to Mr. Suazo for pilot.
Thank you, Mr. Chair. I think that Mr. Rankin and Mr. Beck sufficiently captured anything that Pilot intended to say in its oral argument, so I defer to their arguments and positions. As you know, Pilot has a fairly small interest in the EMSU, but is concerned about the implications of the Commission's decision for its interest inside and outside the EMSU. And so I would just reiterate that we support Goodnight and Rice's concerns, as well as the very valid and real concerns that were raised today by OCD.
Thank you very much. In that case, unless anybody is clamoring for a break, I believe we're now ready to start with rebuttals. Seeing nobody needing a break, I will turn the floor over to Mr. Rankin for Goodnight.
Thank you, Mr. Chair. We heard a little bit about a revisiting of the commission's orders and some of the findings. In fact, starting with the fact that the commission found that Empire has the exclusive right in the EMSU, but the exclusive right to produce, that was the limitation of the unit agreement and the authority under the leasehold interest that they have. The order, the commission's order and the EMSU unit agreement says nothing about other operations, including the rights of other parties with interest in the pore space to conduct their operations. We know that because the order issued by the commission granting the water flood rights and the unit agreement did nothing to prohibit the existing saltwater disposal operations that were occurring then in the San Andres, and did nothing over the last 40 years to prevent that ongoing injection from continuing. We heard a little bit about also the oil saturations throughout the EMSU, including in the San Andres. We heard specifically about, but what we didn't hear was specifically what depths, specifically what zones. We heard, in fact, even that Goodnight's witnesses testified that there is recoverable ROZ in the San Andres. Well, that couldn't be farther from the truth as to the disposal zone. You need to understand what depths are at issue. And all the depths that were just referenced are all above Goodnight's disposal zone. When you go through the record, and you see this in our application for rehearing, none of the depths at which there are potentially an ROZ include Goodnight's disposal. We heard a little bit about complaints from Empire Council that we were focused on economic recoverability. Well, in fact, actually, that's just a icing on the cake. What the commission found was that there hasn't been proof of physical recoverability. That's the main point, physical recoverability. We just were making the point that the commission didn't even need to get to the next element, which is whether or not it's economically recoverable. The question about whether or not the order provides or finds that injection into the disposal zone cannot coexist with a CO2 flood project. Just to be clear, our view is that as to the order, there's no direct finding that they cannot coexist. What the order found was that injection into, if a CO2 flood were to occur within the same zone as disposal is occurring, it may affect the economics negatively, and it may affect or impact the management of the CO2 flood. But what matters is whether or not the CO2 flood is occurring in the same injection zone or not. And only then, if injection were to occur, if the CO2 flood were to be targeting actually the disposal zone, then there might be an issue at best under the divisions, under the commission's order. As to the, and I'll just pull up on my screen. See. Now, as to the communication issue between the two zones, the findings that the commission made, as Mr. Beck pointed out, is that currently the actual physical proof of communication is non-existent. What the commission found is that because of, even after 60 years, after 300 million barrels have been injected into this disposal zone, there is still not an increase in pressure, a marginal increase in pressure, and it is a unique circumstance. So what we know, is based on the best physical evidence, is that there has been no communication because, as we know, Goodnight's injection continues to be on vacuum. With a vacuum, injecting under vacuum, it's a physical impossibility for that fluid to migrate upwards into the overlying zones. Now, on the question of overlapping authority and whether or not how exactly the authority of the order would be implemented by the division. We agree that the language in the order saying "in order to" is very important. It's critical. And what that means is, at best, injection from Goodnight's disposal operations should not be suspended until Empire has the following in place. First, it needs to attain compliance with the division's regulations and requirements. As pointed out in the division's briefings, they must comply with all division regulations, and currently Empire is out of compliance. It's got more inactive wells than authorized under the rules. We've heard from Commission Council that they are ready, able, and willing to go forward, but they don't yet have compliance with the division's rules. They have more than twice the number of inactive wells currently in place. They need to obtain the regulatory approval from the division for a CO2 EOR pilot project, if that's even possible. As we know, there are, from the record of the hearing, there are serious doubts that CO2 would be contained within the Grayburg or the EMSU, making that project potentially unviable. Then they would also need to implement the necessary capital expenditures and facility modifications in order to receive CO2 and implement their project. And they would need to be prepared to immediately commence CO2. Empire fails to explain why suspension is needed now to accomplish this these potential future necessary steps. As the order points out, suspension at best would be required only if and when Empire is prepared to commence a CO2 flood in the same zone as Goodnight's disposal.
Your time is about up, so I encourage you to wrap up quickly.
Thank you. On the question about whether or not there's potential for preventing Empire from conducting this experiment, there's nothing in the record. There was nothing. The testimony actually is that there's nothing technical preventing Empire from doing this work now, today. Nothing. The only thing that's preventing them is their own management has decided, imposed on them, prevented them from going out and spending additional funds. But there's nothing technical that's preventing them from going out to confirm the viability of their RZ project today. And they can go do that and bring that evidence to the commission tomorrow if they are able to obtain it. With that, if there's any further questions, I stand for questions from the commission. Thank you.
Given that rebuttals are fairly brief, if the commissioners wouldn't mind holding questions, just letting everybody get through the rebuttals, and then we can have questions for all council at the end. If there are no objections. In that case, I will turn to Empire.
Thank you very much. We'll go back to the order very briefly. One thing the commission still hasn't heard after all this briefing and the argument is how, in light of the commission's factual finding under subsection 3A of the order, that we adduced substantial evidence of the possibility of future impairment of correlative rights or waste in the EMSU, how on earth any injection can continue and should not be suspended immediately. If we go down to the discussion that follows that, this all comes back to fluids not being contained to any injection zone. Here, they've gone back to playing the injection zone game. So that the commission recalls, they have perforations from top to bottom. It's throughout our unitized interval. And in the Rhino well, the commission even calls out in the order the proximity to the Grayberg. That this cannot coexist with the idea that they continue injecting. It has been found that it is not being confined to the injection zone in the citation to Dr. Buckwalter's work. Second, the EMSU here gives exclusive rights to Empire to operate here. They purchased those rights at paragraph 26. We've heard they cannot exist together. At paragraph 26, this commission has found that Empire purchased the EMSU for a San Andreas EOR. Full stop, period. And we own those rights. And the commission has found at paragraph 27 that we have the exclusive right to decide how to best extract oil. And we have the finding later that says the two of these things cannot coexist. That alone is fatal. So paragraph 3A is fatal out of the gate under the regulations on failed to confine. It's fatal in the sense that it's found waste in the future through substantial evidence to the Grayberg and lack of confinement. And it's fatal in the sense here of the EMSU giving us the exclusive rights. Suspended. I want to talk about suspended. If you look up the dictionary definition of suspend, it's different than curtail. OCD and Goodnight have spoken to curtail, which is to scale back. Suspend, if you look at this, it is stop. The commission's order says stop, suspend, and it doesn't give OCD discretion to decide if in the future they will suspend it. It says implement the order. And the order says suspends, present tense, suspends, full stop. Additionally, there's been zero citation of an instance in which someone has a permit that has been suspended, as this commission ordered, but it's allowed to put in some wastewater. The OCD's argument has been so strange in terms of the position. All throughout 18 days of testimony, we heard questioning and time was spent with witnesses. And at the end of that, OCD dropped the case on a settlement that was concerned about water. And just a matter of 2 months ago, before they dropped their case, they wanted groundwater monitoring. They were so concerned about what Goodnight was doing, not Empire. They were so concerned about Goodnight that what they contracted for were ground monitoring water wells. Have you heard anything whatsoever here about ground? What testimony came in since the settlement agreement for groundwater monitoring wells that has alleviated OCD concern? Additionally, safety. Now there is lip service to safety. There is zero I would encourage OCD to point out in this record where there is one word about safety concerns anywhere in the evidentiary record, let alone in the commission's order. It's not there because there's nothing unsafe about putting injection water down a hole. Zero evidence. Staging. There's zero testimony about the staging that would be needed or the exact parameters of an EOR project. There's none of that in the record. And in fact, here it appears OCD has prejudged this without hearing anything from Empire in terms of particulars. They've already been happy to put out what they think the
I'm going to
staging
object to
plan-
that characterization. We're talking about no evidence here, and that's exactly what that statement was.
Noted. Please proceed.
Mr. Moander for OCD will be able to come back in his rebuttal remarks and direct the commission to testimony here about a reasonable time frame on the staging of the particular pilot program that the commission has allowed us. None of that testimony. And in fact, if you look at the OCD's pleadings, as we dealt with OCD pleadings and examination of witnesses, zero concern, zero testimony. They brought no witnesses about staging. With respect to the idea that Empire has suggested that under the commission's order, it was allowed to go out there and start an EOR project and start poking holes without going through a permitting process. I would ask OCD in its rebuttal remarks to direct where in the verbiage of anything we've said or filed that came anywhere near the idea that we have carte blanche to do what we want without going through OCD procedures. Never once has Empire taken that. That's a straw man argument. I don't know why OCD here on the record, OCD being a regulatory body here, had remarks about an Oklahoma headquarters. As I just talked about, it was bizarre. I don't know why we're hearing about Oklahoma from OCD. I also don't know why we haven't heard about the groundwater monitoring wells, which was what they spent all the time in the case on. If Empire fumbles, waste occurs. There's zero testimony that, let alone finding in this order, that if Empire fumbles the EOR project, waste occurs. Waste is a concept of what's happening within our EMSU boundaries. If they're talking about there would be less oil recovered outside, there is zero of that testimony anywhere in this record in any shape, form, or fashion. I would ask them to direct the commission where in the evidentiary record it was that actual volumes of oil wouldn't be collected. Physical recoverability, the testimony is uncontradicted in the case. 7 barrels of oil came up out of the San Andreas without any water flood efforts and without any EO. This is no CO2, this is no water. 7 barrels came up. It's there and it's movable. That's in the record. They chose to, in terms of injection zones, they made the decision to play the zone game. And as found repeatedly in the commission's final order, they were unable to identify any zone that would be confining. And in fact, that's exactly counter to the findings on Dr. Buckwalter's work.
Your time is almost expired, so I encourage you to wrap up quickly.
I guess to just close, being my final plea here for Empire, the commission is exactly, the injection and the EOR cannot coexist. Empire purchased these rights as found by the commission. It purchased them to conduct the EOR. This has been found. It's in the 1984 unitization order. There is zero compelling reason here for this commission to retreat from its order that these volumes are suspended, not curtailed, or to retreat from its finding that we proved by substantial evidence that this RAWs and that there's a possibility of future impairment down the road. There is zero, after all of the briefing, there's no case, no statute, no prior OCD action, no prior OCC action to suggest that this commission should retreat 1 inch from the findings it's made. Thank you.
Thank you very much. OCD, your rebuttal, if any?
Yes, this will be short, Mr. Director. It's curious that Empire's counsel wants to argue the idea that there's no case where there's been a suspension but allowed more water, but can't provide a counterexample, which sounds a lot like the problem the OCC is currently facing and has been struggling with. So, but of course, Empire wants it to cut one way for them and not necessarily for others. So that's worth noting. Secondly, regarding the Saltwater Desert, the Safe Drinking Water Act, Mr. Waymeyer is correct, except OCD re-entered the case on a totally separate issue, which was an unanticipated order that language the OCD did not anticipate would be forthcoming. And so, of course, the OCD as a regulator is interested in sticking its nose into such matters and requesting relief from the commission. Safety. This is exactly what I'm talking about. Empire doesn't care about any of this, and this is something OCD is obligated to be concerned about. It was raised in Exhibit A to its rehearing filing. It's in there. It was addressed. It's not brand new. Empire didn't avail itself of a response to that. And finally, well, discussing the issue of behavior by Empire, OCD doesn't have a record, to the best of counsel's knowledge, of Empire ever expressing any interest in this project. It only got revealed through this litigation. And I think that does reveal a mindset of the company, which is they haven't conferred with OCD at all. They want to ramrod this through a hearing and tried to secure, apparently feeling successfully, that gave them no restrictions. There was no evidence, oddly enough, indicating that Empire intended to comply with OCD regulations. And this is why OCD is focused more on Empire this round, is because we foresee greater issues with an EOR pilot project than we do with suspension. And that would be why we would be more interested in it. And so at this point, to kind of touch on a few other points, OCD does not have a preference for its any alternative options it's presented to the OCC. The OCC is in the best position to make that determination at this point from OCD's perspective. If there is a third rail, which sounds like the, Mr. Chair may have he introduced that, of saying, you know what, OCD, go do what you need to do. OCD would be less comfortable with that, admittedly, but would comply with that. And so with that, I will pass the microphone over to Mr. Beck.
Thank you very much. Mr. Beck.
I'll be brief. There was one thing I wanted to respond to, which was that no party addressed 3A of the commission's order. And I just wanted to make sure that, and I'm not surprised that my discussion of your comment, Chair, about tends to reduce the amount ultimately recovered didn't just get lost on everybody. To make it plain, 3 talked about grounds for partially granting, partially denying Empire's applications, the applications to revoke the SWD wells. It talks about Empire did adduce substantial evidence of the possibility of future impairment of correlative rights or waste in the NMSU. Now, this section talks about the Grayburg and about the possibility exemplified by the Dr. Buckwalter's Empire Eunice Monument study presentation that with the additional injection from these additional applications for new wells and the additional authority in the Dawson well, that it is very likely under his scenario that water would migrate up into the Grayburg, and that in 49, Goodnight did not prepare any subsurface modeling to support their argument that the water influx from the San Andres to the Grayburg will not occur in the future. Now, no one disputes that there is oil in the Grayburg that will ultimately be recovered today. What the commission found in its order is that those additional wells that they denied the applications to permit would have future impairment and future waste for the oil that will be ultimately recovered in the Grayburg. And so 3A is entirely consistent with what the commission did in its order in denying those applications. That was, and I didn't say it as explicitly as I am now, but that, Chair, was an answer to your question about what tends to reduce means and how I was trying to exemplify the commission effectuated that with the order, is that the commission found that presently the injection isn't interfering with that. Same amounts going in, same amounts coming up, 300 million barrels of oil, very little pressure. And so to prevent the future impairment from oil, recovery of oil, everyone agrees will be recovered. They denied the applications, and that's the tend to reduce prong, but it still requires proof of recoverability. Thank you, Chair. Thank you, Commissioner.
Pilot did not, thank you, Council. Pilot did not reserve any time for rebuttal, but I presume Mr. Suazo is planning to adopt and leave it alone.
Yes, nothing from Pilot. Thank you, Mr. Chair.
All right, thank you. Thank you all, Council. I will turn it over now to Commissioner Lampkin and Commissioner Mpoma to see if there are any additional questions or if we've sufficiently exhausted everyone's patience.
I do have a question for OCD. So OCD said that if the commission decide not to do anything, it will be less painful, but they do not object to that. But I have a question on that. So how is OCD going to implement this order if the commission decides not to provide any additional guidance?
First of all, Dr. Mpoma, I think you may have misheard me. I said it would be a lot more painful for OCD.
But if it's still,
we could still do it. It's not preferred. It's not desired. That's going to require us to get creative for basically a matter of first impression that we've not had to deal with like this before. That in and of itself certainly runs a risk of some delay as we sort out how we will staff this, how it will be addressed. with its own unique parameters. And it also depends on whatever is altered in the remainder of the order. So I can't give you a predictive answer to that, but I can tell you we will address it per whatever the OCC requests of us.
Thank you. So a question to Empire. I want to make sure I have the correct description of the document that I'm looking at. So this one will be the OCD's brief, the OCC's October 17, 2025 order. And I want to read something in page 15 out of 17. So OCD is saying that to ensure that Empire acts with proper diligence and thoroughness, OCD proposes the following performance deadlines for Empire in complying with Order R24004. Can Empire respond to this?
Yes. So again, as we talk about the particular pilot project that would be executed, when OCD offered this, there'd been no dialogue on that. There'd been no technical experts weighed in on exactly what this should look like or how. The Empire, who owns the EMSU and the hydrocarbons in place, what we proposed in counter was 1 year following shut-in of the SWD wells. That is actual suspension. For EMSU to submit the pilot project to the division. 6 months following approval of EOR pilot project by the division for submittal of permits. 1 year to implement any permits after that. That all honors the commission's order to have this completed and to come back to the commission with data and finding for the commission's further action on the suspended permits. And so Empire, the one who actually has paid millions of dollars for this right, that is the counter proposal that we have. And so that there's, I guess this is part of the concern. What you heard was from Mr. Rankin for Goodnight here is that, and I should, at page 34 of the handout, it's there yet. Thank you, Mr. Chandler. But yet you've already heard Mr. Rankin say, and in their papers, in the most recent brief they filed, they said, hey, we're reserving the right to come and object to anything that Empire files with OCD as part of this process. And he's pointing, he says, well, we're going to fuss that they have too many unplugged wells or whatever he was alluding to there. We know that there's going to be regulatory interference here by Goodnight. It's just the deal. They've told you it in the papers. They told you during oral remarks today they're going to do it. So that is part of why we have great concern over the 3 years, but we're going to get it done. But we know there's going to be regulatory interference there through the Goodnight camp, but our counter would be what's here at page 34.
Let me ask you the level of harm that Empire is going to experience if we are to tie, let's say, Goodnight suspension to the execution of a CO2 project. We all know, as Mr. Beck said, once the injection is going on there, it is not really pushing away your resource. That is the oil in place. It's not really impacting that. So what would be the harm here?
There's several harms. The first one is just in terms of our ability to conduct the EOR project. We've got to have certainty about all of the injection stops. We want to be able to go in and do the science to figure out where might be the ideal places to. We don't know. Is this re-entering an existing Grayberg well? Is this drilling brand new wells? I'm so far from any kind of a technical expert, but Empire was consistent in its testimony that before it can even start making those assessments, it has to be able to measure pressures, water saturations to get smart on that. Second piece is, again, consistent with the 3A that we've talked a lot about. This water is not going to be confined, full stop, period. And the commission has said that in citing Dr. Buckwalter. And so we have existing Grayberg production, secondary efforts, movable oil that is threatened, and the harm continues today. Third, the water incompatibility, I mean, I'm disappointed. It's not the commission, it's my fault. I let this get lost in it. But Mr. West put up the chart in terms of how that secondary water flood operation within the Grayburg is organized, the infrastructure. It's like a spider web. And so when you take 1 barrel of makeup water out of the San Andreas, which is this Delaware water of vastly different chemical composition, when you put it into the secondary water flood up in the Grayburg, like a spider, it's in every single wellbore. And you'll remember back to their well was only 4 years old and the well was junk. They had to throw away the whole Christmas tree. They had corrosion down the casing, all kinds of problems in a 4-year-old well. And so as Mr. Rankin alludes to, Empire has a lot of wells out here that it operates. I mean, that's the harm I hear every single time I have a client call is this incompatible water is being distributed across hundreds of well bores with the network. And there's a graphic. The last one that I wanted to point out, and I think is very significant, there's the nice graphic that had the historical water volumes in and out. And I think Mr. West talked about it. I think Dr. Buckwalter talked about. And as you look at the historical pressures and volumes in and out, there's been more water taken out as part of the water flood operations in the Grayburg. And so it dipped down and it's coming, that graph is climbing very steeply. And if you look at the volumes, Goodnight's been carrying on, it's getting more steep. And we're almost exactly back to the original balance point. And so those pressure, I mean, this is just a matter of engineering. Every engineer I talk to likes to talk about pressures. We are back at that balance point and it's just going to go up. And the commission has observed with pressure, you're using more CO2. You have all sorts of problems that come with that higher pressure in terms of implementing it. And you heard from Mr. Macbeth that that CO2 is really, he only had 2 variables. If our volumes are right, the only 2 variables, I'm sorry, you can use their volumes, take their volumes. If you just use our CO2 price and CO2 volumes and use our forward strip price for commodity sales, it's an economic project, according to Mr. Macbeth. So he identified the key variables are how much are you selling it at? And the other key variable was how much CO2 are you using and how expensive is it? With that pressure, and we're right back at the kind of the original balance point going back decades, it's going to be more CO2, which leads to lower economics, leads to less interest and those. So I appreciate that question. Off the cuff, those are the ones that every day when I visit with the Empire folks, I'm being screamed at about this needed to stop yesterday.
The last question for Goodnight. So I'm looking at your PowerPoint page 34. On your first line, you're saying that Goodnight should be allowed to continue on operating until Empire begins SCO2 flood in Goodnight's injection interval. My main concern is on Goodnight's injection interval. Now, so if let's say Empire decides to do CO2 project in, let's say, the upper part of the San Andres, and then Goodnight is injected into the lower part of the San Andres, as part of the hearing, don't you believe that there was not strong evidence established, maybe you can look at our order, that there is a separation between upper and then lower San Andres?
I think that paragraph 56 of the commission's order establishes that there's a very strong separation between the two. And that's based on, and I can share it on my screen,
Yes,
Dr.
please.
Mpoma, and that's based on the finding that there is a substantial engineering basis for confirming that there's no communication currently between the two zones. Strongest evidence for no communication between the San Andres and the Grayburg is the material balance, which is volumes and pressure. And we presented evidence from Mr. Knight and Mr. McGuire, where within 9 months, Empire had injected close to 35 million barrels, all within or just outside the boundary of the EMSU, 35 million barrels within 9 months. And the pressures raised only 0.25 PSI over that period of time. That is clear evidence. And those injection wells continue to inject on vacuum. Continue to inject on vacuum. That's clear evidence that as to between the injection disposal zone and the immediately overlying zones, there is a clear separation between them based on the engineering data.
No, my question is, within the San Andreas itself.
Yeah.
There is Upper San Andreas and then Lower San Andreas. So assuming Goodnight is injected into the Lower San Andreas, was there any, I mean, if you read through the order, was there any establishment of facts that the commission believes that there is a separation between Upper and Lower San Andreas?
Well, I turned to paragraph 56. I believe that that establishes the basis that as between where Goodnight's injection disposal is occurring and any other portions of the San Andreas, there is a barrier due to the engineering data that establishes that.
Thank you.
Any further questions from Commissioner Lamkin?
I think all my questions have been hashed out pretty thoroughly. Thank you.
Thank you very much. In that case, the commission will go into later on, the commission will go into a closed session to begin deliberations on these matters. We do not expect to have a decision for you on this anytime today. We will try to get you a decision as quickly as we can, but you have all filed voluminous materials for us to consider. However, before we go into a closed session and let everybody go home for the, you're all welcome to go home for the day. But before the rest of us on the commission go home for the day, I believe we have one more agenda item, which is an update on pending litigation from our commission counsel.
Yes, Mr. Chair, there's two pending cases. One of them is in the district court. That is the Silverback case. In that case, still waiting for.
Commission counsel, I'm sorry.
I'll wait for them to leave.
Yeah, why don't we wait a minute and give everybody a chance to start their weekends early? Thank you, everybody. We appreciate it. You are all, of course, welcome to stay, but I imagine, I'm sure.
Close things for, I thought we were getting kicked out.
No, we got one more procedural thing and then we'll be going to closed session, but thank you. Appreciate it. Have a good evening. Go ahead. I apologize.
Yes. Zach Chandler, Commission Counsel. There are two items on the litigation updates. One is in the district court. That is the Silverback case or the American Energy Resources case. Still don't know what they're going to file. Their deadline to file what their arguments were, I believe, was yesterday. And then they asked the court for a motion for a continuance to allow them to file a separate court action, which they implied to mean they were going to do a separate court case specifically with Silverback to deal with title issues. So if that's the case, that may be a while before the district court case proceeds.
I have a question about that particular case, if I could. It looked like the case was captioned. I'm sorry, this is the American Energy case, right? It looks like it was captioned American Energy versus the division as opposed to OCC. Does that create a refiling problem given that they've named the wrong party?
Mr. Chair, my litigation colleagues have noticed that, and they are considering those different options, but they have not shared with me whether they're going to pursue that course.
Thank you.
The second case is in the Court of Appeals. That is the PFAS case. In that case, we still also do not know what the advocates are going to be arguing. We do know the Court of Appeals has put it on the general calendar, which means they're not going to deal with it quickly. And they have the court of Appeals has set up a briefing schedule. So later this year, the advocates will put in their briefs, and then the Department of Justice on behalf of the commission will respond.
No further updates?
Those are the two pending cases.
Great, thank you very much. In that case, I will move that we go into closed session in a minute. But first, I think for the purposes of, even though we've now managed to clear the room, for the purposes of deliberations, I will invite us to reconnect in for those of us here in person up in the OCD conference room, and we'll find a way to make sure that Commissioner Lemkin can join us online. With that, I will move that the commission go into closed session for the purposes of deliberating on the application of Goodnight Midstream Permian LLC, and which is a whole series of associated cases, cases numbers 24123, 23614, through 23617, 23775, 24018 through 24020, and also 24025. With that, if there's a second to go into a closed session for deliberations,
Mr. Chair, I second.
is there any objection?
You technically need a roll call.
That's right, we need a roll call. Madam Clerk, would you please call the roll?
Yes. Commissioner Ampoma,
Approved.
Commissioner Chang,
Yes.
yes, and Commissioner Lankin.
Approved.
Thank you very much. We'll be heading into closed session. Will we come back to announce? Well, we may or may not at some point come back to announce ourselves out of closed session today. Thank you.
Okay, so what does the court reporter do then? Do I sit here and wait, or if you
Well,
don't come back?
All we'll do when we come back is to announce that we have closed, we have ended closed session. So I think you're fine to close out your day.
Okay, yeah, when you said you were gonna leave, and I'm just like, well, do I sit here and wait? What do I do?
No, you're all good. I think that's it for, that's all we needed from you today. Thank you so much.
Thank you.
We appreciate you and your patience working through the technical challenges of a hybrid meeting.
Yeah, that was interesting. Sheila, could you please give me a call?
Sure, I do need your phone number unless you want to call me on the phone number that I gave you this morning.
Yeah, I can give you a call there.
Okay,
Thank
give me
you.
just a moment to close down here and call me in about 10 minutes.
Okay, yes, ma'am. Thank
Okay.
you.
Thank you.